Hello, everyone, and welcome to Uncivil Law with my guest, Legal Bites, Alita. Hello, Alita.
Hello, how are you?
I'm having a very decent morning. This is a good morning because we finally get to do something and collab together, which we've been looking for something to do for a while now. So I'm thrilled.
Yeah, I'm
Yeah,
really happy to be on your channel again.
yeah. This is awesome, and we are discussing the lawsuit between the United States of America versus State of Texas. So before this is the district court decision. So before I read this, I have to, or we discuss this, I have to mention the following things. So this was overruled by the Court of Appeals for the Fifth Circuit, and obviously we haven't gone that far yet in our discussion. But I'm going to have to do that rapidly because yesterday the United States Supreme Court granted certiorari before judgment and said that they're going to have oral arguments on November the 1st. So I don't have a lot of time. So that's a thing. That's a thing that happened. Also,
You
more
don't
to the
have a lot
point,
of time. How
the
about the
attorneys.
lawyers?
Yeah. Briefing is this is great.
Oh,
Technically, as I was telling Alita, technically it was a request to stay the injunction. So then the Supreme Court said, okay, we're interpreting your request for a stay as actually a request for certiorari before judgment. We grant the certiorari before judgment. We're now providing the question presented. Here's the question presented. And by the way, briefing is due in 5 days. And then don't worry, because after that, you get 2 days for your reply brief. Ha! And oral arguments on the first. So, as Lita and I were saying, the probable situation at this point is that there's a group of attorneys somewhere in a room surrounded by food that is rapidly getting a musty, unpleasant smell as the sensation of the body odor continues to percolate, with their ties maybe like draped off in in a quasi hungover state as they're trying to speed write a U.S. Supreme Court brief.
trying to fight
Fun,
off a caffeine headache.
fun.
Oh, some
So
poor associates.
yeah, really. But so if you're out there and you're watching this video, first of all, why? You have better things to do. But second of all, I wish you well.
Agreed. I don't envy anyone in that position. I mean, it's and really that's what the Supreme Court decided to do was really take the Halloween season to heart and just turn this whole thing into a thriller for both
Yep,
sides.
that's one way to interpret it for sure. And I was saying to Nick that given this pacing, you wouldn't be surprised to see a decision like by November the 15th, which is pretty quick turnaround for the Supreme Court. It's like normally
Yeah.
it takes them a couple months. Do I think it's going to take a couple months this time? Nope. It's like we're going to have a decision well in time for Thanksgiving, which will make
Yeah.
Thanksgiving all the more wonderful as your Thanksgiving holiday table will be able to discuss the Supreme Court's decision and have perhaps friendly family discussions on the issues that are raised by the case. That could be a real good time for Thanksgiving. So look forward to that. You might want to
Well,
prepare yourself.
yeah. Yeah, now that people no longer have Trump's tweets to talk about, right? It's we've got other issues that come up because the world just keeps turning, right?
So they say. So they say. So yeah. So we're going to discuss this, and we're going to go to highlighting. So Alita, of course, as I mentioned off camera, if there's any parts that you want to highlight or any
Sure.
issues you want to discuss, just let me know when we get to the appropriate page or whatever. Or say, oh, you missed something I want to talk about. We can go back. I don't care. It's all fine. So just let me know as the case may be.
All
So
right.
so
Sounds
first
good.
off, we just have a whole bunch of background on the facts of the background and the procedural background. So I get to skip like 23 pages of stuff, and I'm just going to summarize for you when we get to the highlighting what all the 23 pages I just skipped says. Skip, 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 skip. More skipping. All right, so we finally got to the part where we're going to start talking stuff. So let me tell you about what happened in the preceding 23 pages we just skipped. So there's a whole discussion of the procedure of the history of SB8 and the history of abortion law in Texas. Like here's what abortion law has looked like in the past. Here's some past decisions that are doing this, and then the legislature comes up with SB8, and here's how it became law, and here's what happened in the committees, and blah 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 whatever. Personally, I'm not 100% sure why it really matters because the law can be evaluated without all that stuff, but sure, why not? Let's discuss the factual background in extensive detail. Then we discuss the procedural background. Also, with connection to the whole women's health case, which is a different case on this issue, where a bunch of private people sued a whole bunch of other private people on SB 8. So Whole Women's Health, as the name should imply, is an abortion clinic. And then I think there were some private name parties and there were some other non-for-profits, some other clinics in there, I believe, as memory serves, suing random people. Well, not necessarily random, but people they thought were likely to do it. And that suffered from all kinds of procedural problems because, you don't know that those people are going to stop it. And so the court threw that out, but they mentioned all that procedural history and all that great stuff. So those were the preceding 23 pages. Great. Now I've caught you up to speed. The first issue that we're going to discuss today is the issue of standing. So standing, as I'm sure many of you know, is the doctrine that you have to have an injury that is redressable. So you have to have an injury to you, and the court has to be able to do something about it. Those are kind of the major requirements for standing.
Well, and let's just kind of, if you also sort of back up a little bit too. I mean, in this particular case, so we have our understanding of abortion law or abortion rights right now, right? That pre-viability, a woman has an absolute right to an abortion, or not necessarily an absolute right, but the state just can't put an undue burden on a woman's right to get an abortion pre-viability, right? So it's the way that this statute was drafted. It's a pretty clear, not like violation, but it's pretty clear that it's attacking that full force, right? Mm-hmm. That it's basically trying to rewrite abortion law from that standpoint. So in this particular case, if a court gets to a certain point where they say, okay, we have a constitutional issue here and we're gonna discuss, there are some who would say that would be a pretty clear case that this law violates a woman's right to an abortion as the case law has developed up to now anyway. So right now, the big issue, especially in this case in particular, United States v. Texas, is whether or not the United States, the federal government, can even bring this kind of a case because of the way that the statute was drafted. So they drafted it in such a tricky sort of way to make it really difficult to try to sue someone preemptively under this statute. Unless you are, of course, a random person that wants to sue an abortion clinic. They made it super easy for that, but super difficult for anyone else. Anyway, I just wanted to insert that. And
it's worthy of mention that there is one case involving a doctor. So there is one case with a doctor who performed an abortion in violation of SB 8 quite deliberately with the "come at me, bro." Yeah. People have now come at him.
And he came out with a like an op-ed on it or something, right? And that's how he started to get sued. Yeah. Yeah.
It's been suggested that maybe the people who are suing him are actually pretty friendly with him. It's kind of just a constructed case, which whatever. Either way, it's fine because
there's no restriction against that.
Yeah, there's no restriction against that. You can manufacture a case. In fact, that's happened. In fact, maybe most notably with Rosa Parks, with the Montgomery bus boycott. I mean, that was a constructed case. That was deliberately constructed from head to toe to raise the issue. It's like, yeah, you can manufacture litigation if, it meets all the requirements. So sure, no problem. So yeah, that's fine. So yeah, as Alita says, the issue here is whether or not the United States as such can raise the issue. So do they have standing in this issue? So the plaintiff must have a personal stake, and these three things are required. They must show that there's an injury that's concrete, you were harmed, the injury was caused by a defendant, obviously, and the injury is redressable. So something bad happened, it was caused by this guy, the court can do something about it. That's standing in short. Then the court also notes that it's heightened somewhat in a motion for a preliminary injunction where it must make a clear showing. So the standards for an injunction, or the standards for a TRO, or the standards for a permanent injunction are technically the same, but they're also evaluated slightly differently. The reason for that is because of the timing and the ability of the court to consider the issues. A TRO, temporary restraining order, typically comes extremely early in the case, typically comes basically from one party, and not really for the other party to. It's basically an emergency request. Something so bad is happening that I need the court to step in right now, basically before the issue can really be fully considered. So,
right.
So,
it's so bad, and there's like a high likelihood that person is going to win on the back end of it. And if the court waits until the end of the lawsuit, to give whatever permanent injunction, after trial, then the harm will have already happened, and there's nothing that anyone can do about it, right? Like I always like to use the example of like a historic house or a historic monument, for example, like something that like would need to be completely reconstructed, and then it would never be the same. So
yeah, exactly. So the issue is, in the TRO comes so fast, the courts are rightly skeptical because both parties don't have a full chance to be heard. Preliminary injunction usually comes a little bit later, and with a little bit more briefing, a little bit more consideration. So the courts still are a little bit more skeptical. They have clear showing, but they're not quite as reluctant. And then permanent injunction usually comes at the very end of the case, when, of course, full briefing and full argument has been offered. So the requirements for it are technically the same, but they're evaluated slightly differently because of the timing of those requests.
Right. And they have different results, right? So a temporary restraining order obviously is temporary. So it's only supposed to last until you can, usually for as long as you need, until you can have a hearing in order to argue on the merits with the opposing side, or et cetera, et cetera. So they only last so long at the beginning, but then obviously at the end it's permanent, so it would last forever.
Yeah, fair enough. So the United States is trying to argue that this injures the federal government two ways. It impairs U.S. responsibilities under federal law to provide abortions, and it exposes the United States and third parties to contractor liability. And second, that asserts the injury from Texas and thwarting mechanism. So it asserts it's injured by Texas attempts to circumvent its obligations and thwarting mechanisms. So the very mechanism Texas has created to prevent judicial review is in and of itself a harm, which, to be quite honest, I don't buy. It's I don't even know what the right analogies is, but it's like a carefully drafted contract or a carefully drafted, agreements. Like, we've carefully drafted this agreement to avoid problems, and then you say, well, the very mechanisms we've created to avoid the problems in and of itself is a problem. Now, obviously, in the case of a contract, you have mutual agreement, so the analogy is slightly off, but right. It's something akin to that.
Yeah, I mean, but I do think that the argument about the third party contractors and and the federal agencies, that I think that is a bit of a stronger argument, though.
Yeah, it might very well be. If you can actually show those harms. So we're going to get there as we need to. So we have to show the first issue is, as we mentioned above, a concrete, particularized, and actual harm. So it has to be real. It can't be fantasy. It can't be speculative. It has to be something that is happening or about to happen in about, 5 seconds, as the case may be, when we talk about imminent. So it has to be a very real thing that's happening.
Yeah, it can't be something that's like, oh, maybe one of these days I could face this thing.
That's right.
And okay, I'm kind of scared of that. I don't know.
Oh, by the way, Alita, if I'm interrupting you too much, you can just tell me to shut up and talk, because I don't want to. I don't want to overly dominate the conversation, because I feel like I do that sometimes.
No. Don't worry. I'll jump in. Okay. I know that's one of the things that I need to work on in all of my live streams. It's a lot easier when it's a one-on-one live stream than the mad brawls on Eric Hunley's channel on Fridays.
It's tricky. But yeah, you can't be too passive or you get rolled over. So I'm just saying.
I know, it's so true.
Okay, so now we go to the issue Alita was mentioning just a minute ago, the issue to the federal agencies and programs. So insofar as it impedes the federal government's ability to provide services, the U.S. has met its burden. Now, I agree in part and disagree in part with this rationale. It is true that a state cannot interfere with the federal government. But it's also true a state doesn't have to assist the federal government. So a state doing nothing or a state refusing to help is not a violation of federal law. It's only a violation of federal law if a state is trying to thwart it, trying to prevent the federal government from acting. Like, we're going to arrest your officers. We're going to block your buildings. We're going to, whatever. We're going to prevent you from doing your operations. Federal government's all like, nope, no, you can't do that. You don't have to help, but you can't interfere. So these federal agencies may want to perform certain services. That's fine. But unless the state is actively preventing them from doing that, then I don't see it. Even by shutting down the clinics, it makes it more inconvenient but so there's a couple different issues we can look at simultaneously. The harm to the woman is one thing. So we'll take that aside. Like, is it harmful to the woman to have this problem? Okay, so that's one issue, but let's look at the issue that's actually being highlighted right now. Is this injurious to the United States? So for it to be injurious to the United States, you have to show some interference. So the fact that Texas shuts down every abortion clinic while being harmful to the woman, which is a separate argument, I don't think can be viewed as harmful to the United States because the state doesn't have to help. Do you agree or disagree with any of that?
See, I'm not so sure. I mean, if we are talking about, we were talking offline beforehand about the fact that there are quite a few military bases in Texas. And there are military hospitals on those bases because they're quite large, like Fort Hood, for example, Fort Bliss. Those are huge. And so very often, I don't know if those in particular have provide these kinds of services, but most likely, I'm pretty sure that they do have, maternity wards. They do have OBGYN doctors. So my guess is that they probably do provide these kinds of services because, sexual assault does also happen in the military, and which is unfortunate, more than unfortunate. So it would not surprise me if they also provided those. So this kind of a law would also, and I hadn't even thought about that before reading this opinion, but this kind of a law would create liability for example, military doctors that are performing these, on either women that are serving in the military or women who are connected to the military in some way. To
the extent the federal government is themselves performing these services, then SB 8 would, on its own terms, read on it, which is a massive problem. Right. Because as I just said, you can't interfere with the federal government. So if the forts at their clinics are performing abortions, SB 8 would read on that. And that's a major no-no. You can't do that.
Right. So, but to more directly to your question about these various abortion clinics, I don't know, because I wonder, like, maybe the way that the federal government could get in there is through the funding to these clinics, because there is federal funding that is often provided to, like, Planned Parenthood, isn't there? But
not for abortion because of the Hyde Amendment. There is no federal funding related to abortion. It's prohibited.
Okay. So then, I guess they wouldn't, unless, because another point that they started to bring up in the opinion was the fact that it's also having an impact on, like, the states outside of Texas. Mm-hmm. So as women are seeking abortions in neighboring states, and it's having an impact on the ability of other women to have an abortion because these other facilities elsewhere are being impacted. Which
might be a very valid argument, but the problem is I don't think the United States can raise that issue. If the state of Oklahoma, for example, is being harmed because it's being overrun by people coming from Texas, that's a harm to Oklahoma. It's not a harm to the United States. So maybe you could have an Oklahoma v. Texas, which means original jurisdiction in the U.S. Supreme Court, which is hilarious, but that's not the case we have.
Yeah, but they do have amicus states that are involved.
Oh, sure. Absolutely, of course, the states as amici, absolutely, because they absolutely want to offer their opinion, of course.
Yeah. So, but I don't know as to these individual, like, non-federally affiliated clinics. I think you might be right about that.
Yeah. When you're viewing it from strictly this perspective, and that's why it's like I made a really big point, because you can show the harm to the woman, but that's the harm to the federal government. It's like unless the federal government is itself performing abortions at its facilities, which I don't believe they're doing. If I had to, because I'm not sure that's a thing.
You mean
But
at
if,
like places like Planned Parenthood?
well, I was thinking of places like a military fort, like
Oh,
that
well,
kind of
I
thing,
mean,
or a federal or a military hospital.
but that would be because all the doctors there are in the military. I mean,
Right,
not
but
all
I'm
of
not
them,
sure they're actually
but
performing
a number
abortions
of.
at those places. That was my point.
I would not be surprised. I don't know for a fact myself. I mean, that's something that I would be interested to find out.
Yeah.
But I would not be surprised because, as I said, there's a lot of women having babies out of military hospitals, and they tend to be great places to do it.
So I've been told. Apparently, the military hospitals are the OBGYN goat. Who knew?
At least that's the experience that that my sister had, and that some other people I know have had.
Okay, so then it goes on. Under SB 8, these employees and contractors must face civil liability and damages. Okay, so now let's see if we can get there. For example, the Federal Bureau of Prisons provides that they shall arrange for abortions to take place when a pregnant inmate requests an elective abortion. Okay, I don't buy it because that's not them themselves providing the abortions. Like they shall make a mechanism to provide. But if the state chooses not to help, the state doesn't have to help. So,
but that is the aiding and abetting part of the statute gets them, because they're arranging for an abortion to take place. That's aiding and abetting under the statute.
But the abortion is taking place outside of Texas. Is that a violation of the statute? I don't honestly know.
Why do you say that the abortion's happening outside of Texas?
Because it would have to be, because there's no abortions taking place in Texas at this time. I mean, to the extent it's still happening. Or am I misunderstanding your argument?
I think. Go
ahead.
So any women's prison in Texas would be required under federal law to provide one if necessary or if requested, up to a certain point, right?
Uh-huh.
So this is directly regulating the federal government in doing what they are federally required to do.
Interesting. I think we're going to have to go back to SB 8 on this one, because I'm wondering if SB 8 is limited to abortions that actually take place in Texas. So let me do a quick read here. I can actually just share the screen I'm reading from.
But I mean, it doesn't. I mean, we don't even need to be talking about abortions taking place outside of Texas, because, I mean, as far as anyone would be concerned, I mean, so long as there are women's prisons in Texas, that would be something that they would be required to do.
It's something they're required to arrange to have been done, which is the aiding and abetting element. But they're aiding and abetting, at least because if the clinics were there, then they'd be aiding and abetting them. So, yeah, okay. I think you might be right. Yeah, because if the clinics were there, but they're not there, but if they were there, it'd be a violation, which seems speculative, but you might be right. I'll have to ponder that one a little bit more. Several other agencies of the federal government are similarly impacted. The United States Marshal Service offers individuals in its custody, which would be people in federal custody awaiting, judgment, people remanded, for example, to offers the ability to seek abortions. Department of Defense has statutory obligation to provide abortion services in cases where the pregnant life will be endangered by carrying the fetus to term, or in cases of rape or incest. Right. Department of Health and Human Services Office of Refugee Resettlement may not interfere with access to pre-viability abortion for unaccompanied minors in the agent's custody. I'm not sure. Something about that juxtaposition of elements strikes me as slightly amusing, for lack of a better word. It's these unaccompanied minors who come to the United States now have abortion right where they previously didn't. I don't know. Something about that just strikes me as slightly, I don't know. It's just something about the juxtaposition of elements.
What do you mean?
It's just, I don't know what I mean exactly. It's just, because these refugees presumably were unable to get abortions in their home countries, and now they're here, and now they can get abortions. So it's like, there's something like we're maybe implicitly violating the laws of some other country, or is like the reason that they're coming here is for these services. I don't know. Maybe I'm talking out of school. I could be just being an idiot.
Well,
That's
I mean,
fine.
there's all kinds of reasons why, and I don't know exactly what it technically requires for somebody to be classified as a refugee, but just assuming, for example, somebody who's coming from a war-torn area, like let's say Afghanistan, there could be an issue that some woman went through and does not want to carry a pregnancy to term.
Alita raises the exactly right rebuttal to this. Yeah, there might be people who have been impregnated through some pretty reprehensible methods who are seeking refugee status. So Alita makes the better argument, and I feel dumb, but that's okay. That's one of the reasons we have these discussions, so this is one of the reasons I have discussions with other lawyers, so they can make a salient point. And then I'm like, oh, you're right. I feel dumb now, but at least I have corrected my thinking. So now I've become smarter.
Give me 10 minutes, and I'll ask a really stupid question.
I'm not saying I won't be able to get one at some point, but I genuinely mean this, because one of the reasons I love this discussion, like I had good logic just pop onto the stream I did yesterday when I was discussing the vaccines and vaccines mandates. Mm-hmm. And we had a very intelligent, respectful discussion, and he eventually made a point, and I'm like, oh yeah, that makes sense. And so I have to modify my thinking and modify my argument in this way. But I like that because it's the opportunity for me to be less stupid. Every time someone like that makes an argument, I'm like, oh yeah, now I've gained new knowledge. I've become smarter. So becoming less stupid is a plus. I enjoy it.
Yeah, which is why it's great to get into these discussions and arguments and whatnot. Like I always welcome the opportunity to discuss things with somebody with opposing views, so long as it can be done in an organized manner and a way that's
respectfully.
respectful.
I mean, the discussion with good logic yesterday couldn't have been any more respectful. Treating me with absolute respect, and we had a very cogent discussion, and I was like, this is great. This is wonderful.
Yeah, I love our YouTube lawyer crew. That's why I love it, because it's like the discussions we get are great, and we don't always all agree on everything. We don't always all agree with everyone in the chat, but yeah, I mean, it's at the end of the day, what we're trying to do is get to the bottom of it, right? And try to come up with the truth with a capital T. If you believe in a singular truth, which I do. I'm
a little bit less convinced of the singular truth, but maybe.
I think that maybe not in all cases, but I think in a significant portion of cases you can come up with the truth with a capital T.
Yeah, one of the reasons I hesitate slightly is because that can lead to some dangerous places, as I think we've seen in cancel culture, for example. It is demonstrably evident that a lot of the people on the extreme left believe in a capital T truth and the one true perspective. And they will go out to cancel anyone who doesn't agree with them because they believe that they have the absolute moral purity that no one else could possibly disagree with. So,
but those are the ones that are saying, speak your truth. Speak, I have my truth, you have your truth, but my truth is the right truth.
Yeah, they say speak your truth, but also here's the one truth, right? You get a transgender person who says I regret my transition. It's like, nope, can't have that. Or a person who says maybe the women and men are not completely equal in all physical tasks, for example, for soccer. It's like, no, I can't argue that. Maybe men should not be in women's sports. No, it's like the one clear revealed truth. And then, of course, when you have different competing one revealed truth, when you have this idea of revealed truth, then basically you have religious wars. That's like different competitions between different capital T truths. Basically, at that point, you have a religious war. Fun.
I mean, what I'm talking about is the marketplace of ideas, of course. Like the reason why I named my cat after Supreme Court Justice Holmes. But it's like you have a competition of ideas. You have to pin them against one another, and then hopefully come out with a winner one way or another. And some people just try to circumvent that competition by trying to outscream the other ideas, and that's not right. That's not how you come to the capital T truth that I'm talking about.
And speech's violence also is not helping with the capital T truth.
Oh, yeah.
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 Yeah. Oh, so, okay. Taking into consideration these declarations and the counter regulations, the court finds the government provides services which would subject employees and contractors to civil liability under SB 8. Possibly. I'm not 100% sold on this proposition, but possibly. As SB 8 forces these agencies to choose between facing civil damages or providing these mandated services, the court further finds the United States suffers a concrete injury to its ability to effectuate the services. The injury is particularized and reeled at the impacted services and agencies. Okay, maybe. All right, so now we're going to get into the second element. So that was the United States suffering some sort of harm. Now we want to get into the issue of the women getting harm. So now we're going to shift our focus. And to do that, we're going to do with parent parente standing. So parent parente standing means basically the state is acting as a parent. So they are fighting for their citizens' rights. So they are, as a parent, would fight for their child's rights as the parent, right? So I'm invoking their rights. It's not my rights, it's their rights. Yeah. But I'm standing in their stead. Parent parente standing is the same idea on the governmental level. The government is standing in
the mama bear government.
Yeah, it's the mama big government who incidentally is implicitly calling us all children, which is slightly annoying. But yeah.
Well, ignoring that overtone.
Well, if they're the parent, what must I be, right? And then they say, if you don't behave, you'll go to bed without supper. Lame. Or we'll lock you in your house forever, and you won't be able to go anywhere. $10 from Mandalore Wise at work listening, so a little late. But on the feds requiring abortion services available for mother whose life would be at risk, I thought there were specific exemptions. You are correct, sir. However, the regulations go further than that. Apparently, at least in the DOD, it also explicitly allows for abortions in case of rape or incest. And as I just understood, for the Bureau of Prisons, in the case of rape or incest, the Bureau of Prisons has to pay for the abortion, which seems odd in light of the Hyde Amendment. But let's look past that.
But my understanding of SB 8 though is that there is no exception for cases of rape or incest, or
there is not,
or life of the mother.
There is an exception for medical necessity.
Oh, medical necessity. That's right. But when it comes to rape or incest, the only limitation on that, correct me if I'm wrong, is that if the man in the relationship, or in the situation, the man who played a minor but decisive role here, if that was
a minor, what does a decisive role? Ouch, Alita.
I'm just kidding. I'm making a joke.
Wow. Jesus Christ.
No, I'm making a joke. But if that was a result of rape or incest, then the man in that situation cannot then bring the lawsuit.
This is also correct. Yes.
Okay.
That is also correct. The man cannot bring the lawsuit in those circumstances. Correct. And also, for what it's worth, the woman herself can't be sued.
That was something that I misunderstood for a while. I thought that the woman could be sued because of the whole aiding and abetting language. Because I was like,
no, they exempted her.
How much more aiding and abetting do you get than like providing the body into the clinic?
Yeah, it's a little bit strange. Like the principal isn't responsible, but all the conspirators are. But that's the law, so deal.
The one who gave the consent for the thing.
Yes.
Yeah.
But everyone else, yeah.
Yeah.
But it's a weird because, it makes sense from their proposition, because by not making the woman suable, it makes it arguable that she's not being burdened because she can't be sued. So it's not harming her, right? That was the idea, at least.
If you look at it very narrowly, yes, that would be the case. But if you look at this in the context of like the reality that it creates and the reality that they were hoping it would create, then of course it creates an undue burden. That's what they're hoping for.
The woman isn't being impacted anyway. No, you're right. Oh, Lord. Okay, so let's talk about this parent parente standing. All right. States have long had the authority to sue private defendants to vindicate citizens' rights, and doing so vindicate the issues of sovereign. This is correct. There's any number of cases that discusses the state's ability to do parent parente standing for its own citizens. So no problem there. Then we get to the tricky part about the federal government, which is like, okay, the states assert parent parente standing is limited to state governments. Okay. However, this assertion is demonstrably incorrect. Okay. In Massachusetts versus Mellon, the Supreme Court indicated in dicta, which you made a note of earlier, it's like demonstrably incorrect and dicta don't quite gel.
Right. So for anyone that is unfamiliar, dicta basically means when a court is writing an opinion, and it's not necessarily something that is like required to get to the reasoning. It's just sort of a statement that they sort of throw out there. It's considered dicta, and it's usually a statement made in dicta is usually something that is not necessarily something that people will be able to very reliably kind of hang their hat on, right? Like if I'm, I don't know if I'm explaining that properly, but like, sure. But basically it's not the strongest authority is what I'm trying to get at.
Yeah, absolutely. Absolutely correct. Yeah. So yeah, as she just said, it's these statements that are not necessary. So yeah.
So,
Indeed.
I mean,
go ahead.
Technically, the Supreme Court did say it, so you can cite it to a higher authority in the court's hierarchy, but yeah.
I mean, people do take Supreme Court dicta seriously, as they well should, but to say that we take it seriously and to say it's demonstrably incorrect, not quite the same thing.
Right. It's to say I don't know that I would agree that it's demonstrably incorrect. I would say there is a suggestion that it's incorrect. There's more of a suggestion that it's incorrect than there's any suggestion that it's correct.
Yes, this is fair. So anyways, that the United States may also sue to vindicate rights. As the Supreme Court has noted, states may not sue the federal government to enforce citizens' federal rights. This is correct. Now, I did a brief Westlaw search on this issue, by the way, on parent parente standing and federal government. I found a total of 13 cases discussing it, which isn't extensive, and a good half of them or more were discussing this issue, where the state and parent parente was trying to sue the federal government, which is a no-go, because it's like the state can't do that, so no. So in that field, it's the United States and not the state, which represents its citizens as parent parente. So this is a bit of a throwaway line. When such representation becomes appropriate, and to the former and not to the latter, they must look for protective measures as it flows from that status. So apparently, the Supreme Court opined that if the state is suing the federal government in parent parente standing, then no, because it's really the U.S. government who's parent parente. Okay. The Supreme Court further led credence to this concept when it relied on that dicta in Mellon to deny Florida leave to sue in parent parente against the United States for instituting an allegedly unconstitutional tax, and then cites this proposition: states do not have standing as parents of citizens to invoke these constitutional protections against the federal government, the ultimate parent parente of every citizen.
Yeah. So this reasoning, it might get you there, but if I were on the United States side, I would still be a little bit anxious about that being held up.
Yeah, I'm not really seeing the current Supreme Court going down that road. If I had to guess where they're going to be going, it's like, no. There might be other reasons to oppose it, but I'm not really feeling that one.
Yeah, because it's and bring up the case law again, because I want to make sure that I'm tracking what I'm saying while I'm saying it. But yeah, so it's just the logic of it. It's one thing to say that previous courts, the previous Supreme Court rulings have shown that, or even not necessarily Supreme Courts, but other appellate courts, district courts, et cetera, if they've relied on that to say that states can't sue the federal government, it doesn't necessarily mean that also indicates that the federal government has an affirmative ability to sue states for the same thing.
Yeah, exactly. It's like it's trying to reason by negative implication. Because the states can't do it, it means the federal government can. It's like, I don't know.
Like it's like it's trying to say that the federal government is the supreme, like rule on this, right? Like it's the ultimate big brother that not that big brother with a big B.
It's
I mean,
also
like big brother, little brother.
Another reason to oppose it from constitutional principles is rooted in federalism, as something we've discussed before. The states have all power except what gives to the federal government. So the states have what's called police power. Police power doesn't mean police. It means the power to do stuff in general, the power to regulate, the power to do all the things. So the states have the powers to do all the things, except where the federal government does. The federal government is a government of limited enumeration powers. So the federal government can only do what it is explicitly allowed to do and nothing more. That might be a lot of stuff, but it's still limited. So if you're trying to figure out like who has all the residual power, and the 10th Amendment tells you this as well, anything that's not given to the federal government is reserved to the states or the people. So It's like, okay, well, this to the extent it exists, and it's not an enumerated power, I think you'd be hard pressed to find it in the Constitution. So it's more suggestive that it's state or personal power. So yeah.
But also at the same time, where there is federal law that conflicts with state law, generally speaking, federal law is going to win, and that's something that we'll get into more as well. The issues of preemption and intergovernmental immunity, which we kind of sort of touched on a bit with the DOD and the state, the federal agencies and that kind of thing.
Yeah, the ability of a private person, because they have standing, because they're being directly impacted. So if you have a person who's like the doctor, for example, it's like, well, I'm being harmed directly because I'm being sued. Can't get much better than that. Right. One of the reasons they could argue is like, okay, this is preempted, so it doesn't make any sense. The problem for the federal government is they're trying to invoke this on behalf of people rather than the people themselves trying to invoke it. So there's something there that raises a concern.
Right. Because they can't just sue for any, state statute that the federal government disagrees with.
So the United States sets out in its reply does not principally rely on parent parente, which is probably a good move because they realize it might be a little bit weak too. And it says it's suing to vindicate its own interests. It does not explicitly rely on parent parente to support its standing. Regarding it argues both quasi-sovereign and sovereign interests. Okay, so they have other reasons to sue. Fine. Regarding these quasi-sovereign interests, the United States asserts its interest in ensuring citizens can invoke the power of federal courts to vindicate their rights is a quasi-sovereign interest in the health and well-being of its citizens and not being denied rightful status within the federal system. But they themselves are not being denied status if they have actual harm. So I don't know that works. The state, in response, argues that SB 8 is not hazardous to women's health. The state, however, the court not need to address the merits of this. Instead, it finds the United States possesses an indisputably sovereign interest. Well, the court is right in so much as it doesn't have to discuss the merits because this is on a preliminary stage, and we're not talking about merits at this point. We're talking about procedural elements. So it's correct to say we don't have to discuss merits, but I find the conclusion that's indisputably sovereign interest a little conclusory for my taste.
Yeah, it does. It does feel a little conclusory. I would agree with that.
The United States argues it has a profound sovereign interest in vindicating citizens' rights and ensuring those rights remain redeemable. In response, the state contends that the sovereign interest in ensuring the states do not violate the Constitution cannot support Article 3 standing. The state supports the suggestion by suggesting the sovereign injuries are limited to those described in SNAP, which include interest in the exercise of sovereign power over individuals and the power to create and enforce legal code. However, sovereign interests are not limited this way. The Supreme Court has found, for example, the state has sovereign interests ensuring it receives an equal share of water. See, this is changing the ball. This is changing the argument. The state says that ensuring states don't violate the Constitution does not support Article 3 standing from the federal government. They're talking about the federal government here. And then the court cites, okay, the states have these interests. It's a directly off-point citation. It doesn't follow. It's a non sequitur.
Sovereign interest in okay. Example, the state has a sovereign. Yeah. I mean, so how does an equitable share of interstate rivers water compare to this situation? Because obviously, in a situation with interstate water rights, we are dealing with multiple states. So you
Yeah.
already have a federal question that's involved in that kind of a situation.
Yeah. The issue here is the states are looking at their sovereign interests. So the states have a sovereign interest in ensuring that they receive an equal share of water.
Yeah.
Fine. Premise accepted.
Yeah.
But that wasn't what the state was arguing by the court's own admission. The state was arguing the sovereign interest in ensuring states do not violate the Constitution. This is the sovereign interest of the United States that they're talking about. Do not violate the Constitution. And then the court turns around and say, well, states have it. It doesn't flow. Tell me I'm wrong.
Yeah, no, this one, yeah, if there's nothing, if that's the strongest argument that can be had in this situation is the equitable share of interstate water rights.
Yeah.
It doesn't, I don't see exactly how it compares to this situation. Or as another example, let's see, it is also a sovereign interest for a state to protect its economy from deceptive mortgage practices.
Yes.
Okay.
But even then, the state is suing in its sovereign interest. So the state's ability to sue in its sovereign interest and the federal government's ability to sue in its sovereign interest are at least separable concepts.
Mm-hmm.
So
yeah, so that one still doesn't touch the Article 3 issue, right?
yeah, not
because we're
to
talking
my
about
mind.
States, not the federal government.
Right. So the
interest
citations do not support the conclusion in my judgment.
Yeah. Okay,
The interests that were sufficient here in these examples pales in comparison to the interests of the United States. This feels, I don't know what the right thing is. Is it begging the question? Is it some sort of straw man? I don't know. But it's like, well, their interest in water is not, it pales in comparison to the interests of the United States, which incidentally, I'm not so sure necessarily is true. I mean, water's kind of important for life too. So, all right. But it almost accepts this premise. It like bootstraps itself. Yeah, these interests are so unimportant compared to the United States interests. So surely the United States must have an interest. If the states have the ability in their sovereign interest to raise these piddly concerns, then it must necessarily be true the United States has the sovereign interest to raise these much grander concerns, which is a premise that does not flow from the premises, in my humble opinion.
Yeah, I don't know that any of those rebuttals to the Article 3 standing issue really overcome it, in my opinion, on this particular issue.
Yeah, it's not really doing much for me.
Yeah, something tells me that the parents' patriot argument is probably going to be the strongest one.
How do you pronounce it? Parents what?
I don't know.
Patriot? I always say parente. I might be pronouncing it wrong. How good is my Latin? Still my 11.
Okay, I mean, well, hey, feel free to make fun of me for any of my pronunciations because I realized
Alita. No. I'm infamous on this channel, particularly when it comes to names and being unable to pronounce them correct. Names
can be hard. Names can be hard. I say coming from like as someone who has a difficult name, like I completely understand.
Alita, but that's not that bad.
Yeah, but you know. It's when people hey, trust me, at Starbucks people have a problem with it.
Yeah. So if I start making fun of your pronunciations, we're in a very much rocks at glass houses situation. So I'm not sure that's advisable.
So let me just as an example. So I went to law school in Texas, and then I went back to California to practice. And I had been in litigation for years, and in California, for whatever reason in California, they don't call it a motion to dismiss when you're in state court. They call it now I will pronounce it correctly. Demur. And for years, I mean, I had never actually had to respond to one or draft one before this point. So I never had to actually talk about one to discuss it. I would read it and then, move on. So I was talking with one of my bosses, and this was like years after having practiced in litigation for a while in California. And he just stopped me and he was like, what did you just say? And I was like, oh, they filed a demurrer. And he was like,
that's the way I pronounce it.
A what?
No,
So I got roasted for a little while for pronouncing it like demurrer instead of demur.
Well, maybe it's a
Because
potato
I
thing,
was
or
like
maybe I'm wrong.
trying to be fancy or something was like what what he was saying. So anyway.
Demur. Okay, fine. Demur just sounds like a noise a cow makes. Demur.
Demur. That's also what it sounds like when you are the plaintiff in that case.
All right. So we've discussed the parent parente standing, which I think has problems. Now they're going to talk about the cause of action itself on a procedural element, and this line I have problems with. SB 8 was deliberately crafted to avoid redress through the courts. Yet it's this very unavailability of redress that makes injunction the proper remedy, indeed the only remedy for the constitutional violation. So as I was explaining to Alita before the stream, this reminds me a little bit of what's called a Kafka trap. The very fact that you deny you're racist proves that you're racist. So it reminds me of that. The very fact that you made this hard to enjoin provides a rationale for enjoining it. It's not working for me. Is this working for you on any level? Because
I've got to say, and I I'll just say it's not doing it for me. It's not that particular logic for me does not.
Yeah, it proves it all the more. It's like, it's an argument you literally can't win. And that's what makes it a Kafka trap, because either way, you literally can't win. It's like, if they made it redressable, you can't win because you gave redress. The very fact they avoid redress makes it all the more redressable. It's like, I don't know, man. I'm not sure about that one.
Yeah, it's almost like an argument between like some feuding couple or something that's like, well, the fact that you don't want me to, I don't know, the fact that you don't want me to wear this dress makes me want to wear this dress even more. So therefore I'm going to wear this one. I wasn't planning on it, but now I will. Like, I don't know. It just sounds like something like that. But I will say that, I mean, that first sentence is not incorrect, right?
No, I don't disagree with the premise that it was deliberately crafted to avoid litigation. I mean, it would be hard to deny that.
But it doesn't necessarily mean, I mean, because it's like you could apply that to any other, that kind of logic to like any other situation. Like, oh, the Constitution specifically forbids, the Congress from making a regulation on X. Therefore, Congress absolutely should have the right to make a statute on, or legislation on X.
Yeah, fun.
So
times.
The logic doesn't necessarily jive.
Yeah. The state, okay, this is also a line that bugs me. The state is mistaken in searching for a blueprint of cause of action here, which bugs me right away just off the top. So basically, I read that as the state is mistaken for looking for precedent. The state is mistaken for looking for any sort of history that might guide this. It's a mistake to look to precedent. I mean, okay. For United States, cause of action is a creature of equity, a centuries-old vehicle which eschews categorical definition. That remedy is available when no adequate remedy exists at law. Any attempt to codify such situations would be futile, and likely require powers of clairvoyance in which no legislature possesses. So basically, at this point, the way I'm reading this, and feel free to disagree with me if I'm reading it wrong, but okay, so the entire history of equity up to this point has provided certain equitable causes of actions and certain equitable rationales, which also provide precedent. But equity eschews all that. So the fact that there's absolutely no precedent provides all the more reason to provide a remedy. Am I making any sense here?
Yeah. So the fact that this vacuum exists means that we need to fill that vacuum.
Yeah.
Essentially.
I mean, it is a centuries-old vehicle. I like the law itself, so fair enough. But I was under the distinct impression. Yeah, I was under the distinct impression that equity also had precedent, like law does. I
mean, now my understanding is that when courts are going to rely on an equitable reasoning to get to a certain result, right? Like it's courts are typically supposed to be pretty limited in that. Like it's really when like they've gone through so many different possible lines of reasoning, and there really is nothing. There's nothing there that could possibly could really do the situation well. if that makes sense. Take for example, the initial Supreme Court rejection of the stay of this law, right? How what's his name, Kavanaugh, how he wrote the not the opinion for it, right? Because it wasn't a
Yeah.
Did he write it? I think he wrote like a
kind of technically, yes. He wrote a concurring opinion, which I guess must be the judgment of the court given marks, but okay.
Kind of by default, I guess, right?
Yeah.
But because it was a per curiam opinion, right?
Yeah.
So anyway, but I mean, he basically said, oh, was it in this one or was it in the housing one for the CDC where he said, I think it was, sorry, I'm totally mistaking this. It was in the CDC rent situation, the rent, keeping people from the eviction moratorium. Sorry, so many words coming out of my mouth that are not particularly precise right now. So the eviction moratorium, when Kavanaugh wrote the opinion denying the stay on that he said, hey, like, yes, if this were a new statute and it was going to be around for a while because of X, Y, and Z, I would say that we should put a stay on this moratorium. But because of the fact that it's going to be expiring soon, and for equitable purposes, we want to be able to give renters that are in a situation like this, we want to give them some time to be able to set up their situation that they can react, so it's not like a total surprise, basically. So that's an example of an equitable reasoning for a particular opinion. And I think that you can agree or disagree, but generally speaking, like, it's hard to be outraged against a reasoning like that, right? Because it's like he's really taking like an empathetic view towards those people, and it's not something that's like, well, this is like for the entire issue at heart. It's just in this particular situation, because there's only so much time left. Let's be kind and empathetic, kind of.
Yeah.
But it's usually not the first thing that you rely on in any kind of a case.
Not really, no. And the fact that it's new equity that we're inventing out of whole cloth makes it all the more concerning.
Mm-hmm.
So, yeah.
Yeah.
This was 113 pages, by the way, in case you're wondering why we're skipping a lot, because it'll be a long time to read and do analysis. So I picked the issues I thought were important. So that's what we're doing now.
Yeah, no, I love it.
You can read the original if you care about other things, right? It's available. It's a public document.
Yeah.
So I skipped a whole bunch of stuff here. Let's see where my next highlight is. It's in there somewhere. Okay, so now they want to talk about the ability of this to be applied to private individuals. So as I'm sure we all know / remember, one of the more infamous aspects of SB 8 was it gave power to literally everybody, except state officials, incidentally. So anyone except them. But anyone else in the world, so the other 6.4 billion people on Earth, to bring suit under SB 8. So that was the way that they were trying to do this, through what we would call a private attorney general action. And as Alita, I'm sure well knows, in California they have a private attorney general act as well. The difference, of course, in California's version is it doesn't strip state officials of their power to do stuff. It just also gives private individuals the ability to raise issues on behalf of the state. So it has to enjoin private parties who bring suit. These private individuals, like the state officials themselves, are acting as arms of the state. The state entrusted part of its enforcement authority to private individuals by deputizing them to bring these lawsuits. Okay. As such, private individuals enforcing SB 8 are properly regarded as state actors. I think this is probably true. Because in this instance, like the Private Attorney General Act in California, in both cases, there's no harm to the individual. The person wouldn't otherwise have the ability to sue. There's no harm coming to them. And incidentally, California is not the only example. There's examples in federal law. For example, in my field of law, patent law, there's a false marking act. So if you falsely mark a product with a patent and you don't have one, a private person can bring that lawsuit to recover. Whistleblower suits are somewhat comparable. So there's other examples like that. Mm-hmm. So these things are not new in that respect. These private individuals are state actors. Individuals suing under SB 8 are not suing for violations of distinct legal duties owed to them, fair, but instead suing for violations of legal duties owed to the public. Okay. Courts have characterized private parties as state actors when a state allows or is involved with conduct that be unconstitutional should the state itself engage in conduct. This is basically correct. If a private person becomes a state actor when they are acting on behest of the state or in sufficient concert with the state. So the example I always like to go to is a police officer can't just go search a home because they want to. A private person can. It's trespassing and a whole bunch of other things. But if a person illegally breaks into your house and they happen to see, and they if a private person happens to break into your house and sees the massive amounts of cocaine, and they arrest him and they say, while I was there, I see massive amounts of cocaine. You're going to have a bad time because that evidence is coming in against you. The private person wasn't acting on behest of the state. They might have done an illegal thing, but it's not action of the state, so it sucks to be you. However, if the police officers just simply like hire or encourage, a private detective to do this, no. Just no, all the no. The police officers can't do it. They can't get around it by, it was a private individual. No.
Right. Because then that evidence then becomes fruit of the poisonous tree. Because they didn't have the right to be there, et cetera, et cetera. Because it's basically you have an individual that has been requested by an actual federal or state actor, employee, et cetera, et cetera. You basically have this person stepping into the shoes of the government.
Yeah, very true. Okay, let's see. The private individuals who bring these lawsuits are in active concert with the state to enforce the law. As the state has acknowledged, the rule was intended to prevent defendants from nullifying a decree by carrying out prohibited acts through aiders and abettors. Okay. The state concerns that private individuals should not be enjoined because they've not been heard by the court conflates persons who are enjoined through injunctions with persons who may be in contempt for violating the injunction. This is also fair. And does seem to be supported by the law. So you can enjoin people beyond the lawsuit because it would be slightly ridiculous if you couldn't. So just imagine that, I don't know, a company is doing an illegal thing, all right? And it's like, okay, we've determined it's an illegal thing. We're going to prohibit all companies from doing the illegal thing because it's an illegal thing. So all those other companies haven't been heard, but the idea at least is that the issues are the same. The legal issues are ultimately the same. So the court has considered all the issues because it's a question of law at that point. It's not a question of fact. It's like they're doing this thing, is it illegal? That's a question of law. It accepts the premise that it is happening. So there's no factual questions in play. Assuming it's true, what is the legal conclusion? The legal conclusion, it's bad. We're going to prevent all the people from doing the bad thing. Okay, that's purely an issue of law. Fine. But then they say, okay, this is distinct from who can be in contempt. So only the parties who were involved in the lawsuit can be found in contempt because they were heard and now they're flagrantly violating the court's order. So that would be contempt. But all the other people who are enjoined were not party to the case. So you can't have contempt of them. So if the people who are heard come into a court again and try to sue, you're going to have a bad time. You're going to be found in contempt and bad things will happen. If other people come into court, they're going to throw out your case, but they won't put you in jail. So that's a plus. The state wrongly assumes federal courts cannot enjoin a person or entity without first providing every possible obligator with notice and opportunity to be heard. In fact, the Supreme Court has upheld an injunction against Arizona that governed the conduct of state and local officers who had not been given notice or an opportunity to be heard. So this is probably correct, but the facts are slightly different, but probably in a way that doesn't ultimately matter. So in the case of the state or local law enforcement officers, they're still instrumentalities of the state. So if the state is being enjoined, the fact that these other particular officers are not being heard, there are direct instrumentalities at state. It's slightly different here because these are private individuals, but ultimately, I think the legal conclusion is correct because they are acting in close concert.
Right.
They're state officials and they're state officers and don't have to give notice. So I think the conclusion is ultimately correct from this premise. So see,
Yeah.
I can say, yeah, this is not quite on point, but nevertheless the conclusions hold. I can do that when it's warranted.
Yeah, no, I would agree with you. I think in this situation you do have people that are stepping in to fill the shoes of what otherwise would have been the government.
Interesting comment from John Smith, which is interesting. This conversation seems a bit more based on emotional reasons than I normally expect. I mean, I respectfully don't agree. I don't think
Yeah.
I think it's a pretty good legal analysis. What do you think, Alita?
Hey, I gotta say, I mean, just if you want to talk about biases, I don't like this law. So I would like to find, reasons why this reasoning is great that the United States wins this case, because I personally don't like this law. I don't like what it does. I don't like the way that women's that it opens up so many women for their medical information to come out at trial and litigation. And I don't like it at all. I don't like that so many random people off the street can just sue any woman, or not any woman, but obviously you can't sue the woman directly. But I mean, we're not even talking about women that necessarily actually had an abortion, but just they could have some sort of a suspicion that she
contemplating
did.
one, because people who are planning on it can also be sued in that way. So yeah,
right, and it's even if she's not actually sued as a defendant in the lawsuit, her information gets made public, because everything that comes out in litigation gets made. I mean, not you can have protective orders and all that kind of stuff, but really, that's a lot. That's a lot. In an already emotionally charged situation. That's a lot to deal with. So I don't like this. I don't like this law at all. So if anything, I would be looking for reasons why this opinion, which the spoiler alert is that the court ended up
being reversed.
Yeah. Well, right. Yeah. But I would love to agree with this particular court's reasoning, but there are problems with it.
Yeah. I think it's been a pretty reasoned analysis. We've tried to explain the legal rationales behind it, and at no point in this discussion have we discussed the underlying morality of abortion, because at least on my channel we don't typically do that. It's very rare when we do that, because the moral questions. First of all, I'm no more an expert than you on the moral questions. So, and second of all, from a legal perspective, it doesn't matter. So, I don't think we're just discussing the law. Can this law stand? Can it not? We're not we're not saying whether or not abortion is good. We're not saying, whether or not this is good. I will also echo Alita's comments. Although my concerns about the application of SB 8 in its own terms are less than Alita's, my concerns extend to how SB 8 might be able to be applied in other contexts, which is my concern.
That's
because it provides a technology. Now, it may not be able to be cut and paste. You can't just replace abortion with Second Amendment or guns or free speech or something. It might not be quite that simple. But there's an underlying technology that underlies the decision that I think can be read and written onto the other thing. So it's if this is
Second
true,
Amendment rights, for example.
Yeah, which I care about quite a lot, or First Amendment rights, which I care about a lot. So I'm not as concerned about the medical privacy issues as Lita, although her concerns are valid. So don't mistake me. I'm not saying her concerns are invalid. They're valid concerns. I'm more concerned about these the applications outside this and how the technology might grow well beyond its own domain.
Yeah.
So,
and there's also another question in the chat about what it means to enjoin.
Okay. Yeah. So enjoin just means to stop.
Yeah.
You're prevented from doing something. Enjoin or injunction just means it comes from the word injunction.
It can also mean to require someone to affirmatively do something, but that's less often. It's usually to make someone stop doing something, like a factory that's polluting waters or something like that. A court can tell them to stop stop doing what they're doing in their factory that's actually polluting the water. So that would be an injunction. So enjoining is that's the verb version of an injunction.
Yeah, Matt K, for whatever it's worth, I'm conservative, and I think my explanation of why I'm concerned about the law was fairly conservatively rooted. It's like I'm concerned about the application of the Second Amendment rights, which I think is, more conservative concern, but you do you. Okay. Yeah, so enjoin just means to stop. It comes from the word injunction, and injunction is a command.
He may have been talking about me. Because there's been
I don't know how liberal you are or not, Legal Bites. I mean, I don't know how legal, we never really had a discussion, nor have I really cared.
I'm like center right.
Yeah.
So, but for some reason, I've developed an impression on some people that I'm like super left. I don't know what it is, but
occasionally I get called left, which is hilarious.
Yeah, I mean, I've got a bit of a libertarian bent, I think, but not to a radical extent by any means. But yeah, so I think it's funny. But anyway.
Okay, so the state wrongly assumes that it can enjoin this without giving everyone an opportunity to be heard, but I think, as we discussed, that's not quite right in this situation. So I think we agree as to that aspect. Let's see if I have any more highlighting in this document. I'm not quite sure if I do or not. Okay. So then we discuss this undue burden test. Okay.
Right.
So we have to I want to give a preliminary in two parts. We have undue burden, which is from Casey versus Planned Parenthood. So it basically says in so many words that an abortion before pre-viability must be allowed and any regulation must not place an undue burden on the woman. So those are the magic layers. And then we get into whole discussions about what undue burden is, and welcome to less than 30 years of law.
That's where the fight has been, is what is an undue burden, what is and is not.
Yeah. Okay, so that's Casey. And then the Texas ban also itself has this undue burden. And it seems to read, at least the way I read it, that it seems to be adopting and tracking Casey. But it's an affirmative defense, right? It's something that, so the way that Casey can be understood might be the other way around. It's like, it's not an affirmative defense. It's something so it's like a burden of proof issue. Like the state under Casey is burdened to prove their regulations are not an undue burden. In this case, the defendant, whoever that might be, is tasked with providing it. So it shifts the burden of proof. So that's, I think, the major distinction there. So just keep that in mind. Mm-hmm. More specifically, an undue burden is shorthand for the conclusion that a state of regulation has the purpose or effect of placing a substantial obstacle in the path of a woman. Well, that doesn't really help me that much, because that sounds, you just said the same thing twice as far as I'm concerned. But okay, sure, why not? It's like, what else would it be? Okay. These provisions operate and were intended to operate as an effective deterrent to provision of pre-viability services in Texas. Okay. Precluding the vast majority of individuals from accessing this constitutional right.
Precluding the vast majority. I mean, I don't know what the data is on that. So that would be a fact.
Well, they did basically shut down all the abortion clinics in Texas, so there's that.
Although, yeah, I think earlier in the opinion, I think they said something about how like they actually did have some numbers that they cited to, or something like that, to say that I think most abortions happen before 12 weeks, but after 6.
Washington Daily says, asked about the stream with Eric Huntley, shows she's on the left side. So without even asking her first, I'm just going to say that when you're conservative, it doesn't mean that you can't agree with the left sometimes. But sure, tell us about your extreme left-wing views here.
Hold on, pull that back up. Are you referring to the AI or whatever that looks at the sources of media that you interact with on Twitter? Because if that's the case, that's a ridiculous way.
Did you get rated by the bot as left?
I don't know if that was it, but it was.
I got rated as right, partisan right, libertarian, anti-SJW, and a whole bunch of other things.
I'm not big enough. That's the one with like all the different bubbles.
Yeah.
I'm not big enough to show up on.
Not big enough for the bubbles.
Yet. No, but the one where it's like it looks at your like media diet, like what kind of media you like take in on a regular basis, and that you interact with on Twitter. So the fact that I like interact probably most often with like The Hill or NPR, CNN. I also follow Fox News. I follow, Post Millennial. I follow a bunch of these, and I don't know, like, who cares?
Do you like Ben Shapiro?
Yeah, I do. I don't always agree with him, but I do like watching his analyses.
Yeah. So yeah, I read left wing sources too. So it's fine.
I that's the thing, is that, like, in order to really, like, this gets back to what we were talking about earlier about trying to get to the bottom of things, right? Trying to get to the truth with a capital T. In order to do that, you have to be able to confront. Arguments from all sides, right? Like when I'll say that, when the George Floyd protests were happening, and it was one of those like overnight things that happened, and I am always like instantly suspicious of hashtag campaigns that seemingly come out of nowhere and just kind of like take the world by storm. I'm always instantly suspicious. And so I was just like, I read White Fragility, completely disagreed with it. Completely.
I haven't read it, but I've heard tell. It doesn't sound like worthy of my time.
But it's, whatever. Like I read How to Be an Anti-Racist. Like, it reminds me.
Wow.
I did. It took me a while because I had to put it down for a while. But it's, I never want to be intimidated, or I never want to, put myself into some kind of a silo, because I want to be able to interact with people of all opinions. I have friends that are very, very conservative, like very conservative, and I have friends that are very, very progressive. And I don't know. I don't know what to say. but apparently, I mean, so and then sometimes I get the last one of the last live streams I had, there was somebody that was like totally on the left, that was also like had become a total chat troll. He was my first chat troll. So I don't know. I mean, you can't please everybody, but it's fine.
That's true. That's for damn sure. One preventer lamented, now that abortion is almost entirely inaccessible in Texas, patients have fewer options, and each of their stories is more heartbreaking than the last. That rubs me the wrong way for some reason. Indeed, it's dismantling of the provider network that constitutes undue burden on access to abortion. So here, I'm going to quote Nick Rekieta, because Nick Rekieta raised this point, and I want to give him credit. So he said, okay, how can it be dismantling the network? Isn't it true that, for example, Planned Parenthood provides many services other than abortion, right? They're not just, it's calling them abortion clinic is misleading. They provide all kinds of services, exams, breast exam, monograms, STD care, prevention, blah, 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 right? They provide all kinds of health care. So how can it be that the network is dismantled? Why aren't the Planned Parenthood still running, except not providing abortions? So I thought that was a very good, very good point. The most probable conclusion is because abortion is such a huge money grab that they literally don't have the ability to operate without it, which is also kind of hilarious. So it basically, the fact that they're not still operating, it's not still providing all these services, kind of puts a lie to the fact that they're not really an abortion clinic. Those really other services are not. That's kind of what the conclusion is, right?
Yeah, I think that there may be something to the economic impact of it, because I think that it could be that the greatest way that they make their money is through these other services. Remember when there was that huge that outrage that happened because there was a woman that was like she worked at Planned Parenthood or something, and she was like out at lunch with someone and talking about how they like harvest organs or something like that and sell them.
Oh yeah, well, that was shit. I know the name of this. Who was that? It was Christ. They're a famous organization who sets them up and does those kinds of things. Damn it, I'm not gonna remember.
Yeah.
Oh well.
But I don't know what their financial situation is, exactly how they make their money, how they run or whatever. But I wouldn't discount the possibility that them not being able to provide abortion services has a significant financial impact on their ability to run.
Yeah, exactly. So, and then I like this from Grimm's Bar. Almost entirely, that's oxymoronic. Well, that's a hazard of lawyers because we avoid speaking in absolutes.
Yes.
Speaking in absolutes is problematic. So yeah,
We're
that's just a
allergic
hazard.
to
That's just a
absolutes.
hazard of being a lawyer. Um, okay, then the same provider noted credibly that SB8 is like no other abortion restriction or ban we've dealt with before. Well, this is true and kind of the point of SB8. And its immediate impact on staff has been truly catastrophic. On our patients, staff, and physicians has been truly catastrophic. Now, on patients, maybe. The impact on staff and physicians has been catastrophic. I mean, how can you read that other than our staff and physicians are unable to keep providing abortions, and we love the abortions and we want to keep providing them? It's catastrophic. We can't keep doing the abortions. Is there another way to read that?
I mean, we'll pull it up again.
Sure, no problem.
Let me just scroll up just a little bit more again. Oh, well, there's all the
So I'll just read it before. The same provider noted credibly that SB8 is like no other abortion restriction or abortion ban we've dealt with before, and its immediate impact on our patients, staff, and physicians has been truly catastrophic.
Yeah, and they may be talking about emotionally.
They're emotionally sad that they can't keep providing the abortions.
Yeah.
We love those. We love those abortions. It's our day and day. It's our day and day out work. We're all about those abortions, and we're sad we can no longer do the abortions.
Hey man,
is that what they're going for?
I could never do it myself. But there are some people that feel a certain kind of calling, I suppose. So, they may have a sincere emotional response. Whether or not that's appropriate is, up to each individual to decide.
I can understand someone making the decision to perform those services, but if it's your calling I don't know, man, that's something's off about that. Yeah.
Some people feel very passionate about the work that they do.
I guess
you can just say that. I mean, hey, you could say the same thing. I don't know, maybe an executioner likes his job. Not to say that that's the same thing.
Again, that would raise similar problems. I'm not sure that an executioner should necessarily be gleeful or sad that they can no longer do the executions. That strikes me as off.
and that's also not necessarily to say that that's like the same exact thing. Although some people will say that it is. Of course, I'm sure that people in the chat will.
Oh Lord, yeah. I always love those discussions because they're stupid as hell. It's like, if you're pro-life, why are you pro death penalty? Well, let me think about it. This fetus has done nothing wrong. The person with the death penalty has committed aggressive murders. So maybe I distinguish on those grounds. How about that? That'd be great.
That's a logical argument.
Although these days I'm a little bit more. This is off topic, but I'm a little bit more skeptical of death penalty. I'm not really sure it's worth the effort. It's a bad analogy in this example, but the juice isn't worth the squeeze. I'm not sure what we're getting out of it is worth what we're putting into it. So, yeah. Is there anything more highlighted in this document? Let's see. I'm just scrolling until we find something. Okay.
Yeah, and somebody in the chat just said they can get sued by people who think they're providing abortions to employees doing their tasks. The sewer does not know. That's true. That's true. You don't necessarily need to have the evidence to say like this absolutely happened at this facility. You can sue and then find out in discovery.
It'll be an easy motion to dismiss. It didn't happen. Go away.
Because that's a factual argument. So you wouldn't be able to say that for a motion to dismiss.
Okay, so now we want to talk about this undue burden that was put into the state law. So we've moved on from Casey to the one that's codified, which changes the burden of proof. The undue burden affirmative defense also fails to save the law in the event that the law is understood as a regulation rather than a ban. And assuming the deterrent effect of the law has not succeeded to the extent a provider can still be found to perform a procedure. So this is a regulation, and even if it's a regulation, even if providers are available, it still fails. Okay. The Casey court was clear in defining undue burden. No, they weren't. Whatever else can be said, to say they were clear about defining it, no. I mean, we've had 35 years of litigation trying to figure out what the hell it means. So just no. Explaining, because we set forth a general application to which we intend to adhere, it's important to clarify what's meant by undue burden. That would be helpful. The extent the opinions of the court or individual justice use undue burden standard in a manner that's inconsistent with this analysis, we set out the controlling standard. Well, they didn't really provide anything, so yeah. The affirmative defense written in SB 8 bears no resemblance to the Casey standard. I don't agree with that. I agree it shifts the burden of proof, which might be enough. And so, you go ahead.
I mean, because Casey... I mean, because SB 8, we could say, does very clearly cause an undue burden, right?
Well, SB 8 by its own terms exempts anything that would create an undue burden. So it has this like clever idea that, by its own terms, SB 8 does not apply if it would create an undue burden. But it's on the woman to prove that.
On the woman to prove that, the woman that's not a defendant, and then no one else can make that defense, right?
Apologize, not necessarily the woman. I misspoke.
Okay.
Whoever the defendant would be in this example.
Okay. So, but I thought undue burden was not. That's a constitutional argument that they excised out of potential defenses.
No, they gave it as an affirmative defense.
Oh, they did? Oh,
yeah.
Okay. Then I okay. It's been a minute since I read through the.
Or maybe I'm just misquoting SB 8, so I could double check. Let's see. Because if I'm wrong on that, I'm gonna have a bad time, and my analysis has to change radically.
Yeah. Oh, no, you're right. So a defendant in an action brought under Section 171.208 may assert an affirmative defense to liability under this section if, number 2 is the defendant demonstrates that the relief sought by the claimant will impose an undue burden on that woman or that group of women seeking an abortion.
Yeah. Yeah, so that's where they're trying to do it. So I don't agree, because they don't attempt to define undue burden, which can't be incompatible with Casey, because it sure didn't. But it shifts the burden of proof, which might be enough, but that's not what the court's reasoning is. So, yeah. Further, it's implausible that this obscure and somewhat unclear provision in law, I don't agree with that either. How is it obscure? It's explicitly mentioned. An unclear provision of law, it's only as unclear as Casey is. So, there's that. But why are they calling it obscure? It's not obscure. It's expressly mentioned. Okay. Will be sufficient to convince providers to continue abortions in the face of all the obstacles discussed above. Well, the conclusion is right despite the premises, because most of them is shut down. Unless it has this effect, this affirmative defense, despite its name, has nothing to do with lessening the burden imposed. Having found that Section 3's post-embryonic cardiac activity ban is likely unconstitutional, the remaining provisions of SB 8 must also be found facially invalid, as this court declines to comb through SB 8 in piecemeal fashion after determining the statutory provisions at issue are facially constitutional. I take a bit of exception to this as well. To say that provisions of the statute are unconstitutional, fine. But the court's saying, basically, as far as I'm reading it, I'm basically refusing to do my job. I'm refusing to see if other provisions are constitutional, and then go to the next part of the analysis of can those be severed, which there's a whole severability clause to deal with it. But I very much dislike this. What do you think, Alita?
So, yeah, I mean, I'm still kind of. I'm not gonna lie, you kind of lost me a little bit here.
I'm sorry. I can say it again.
Because tell me your point one more time.
So I'll read it again and I'll try to give my argument again. So what it says is, having found that Section 3's post-embryonic cardiac activity ban is likely unconstitutional, the remaining provisions of SB 8 must also be found to be facially invalid, as this court declines to comb through SB 8 in piecemeal fashion after determining the statutory provisions at issue are facially unconstitutional. So as I read that, the court is saying, okay, I have found particular statutory provisions of SB 8 to be unconstitutional. Yeah. Great.
Yeah.
But then it goes to the conclusion the remaining provisions must also necessarily be found facially invalid, which doesn't flow. As the court declines to comb through it, which doesn't in piecemeal fashion, which is the court being lazy. Because normally the way you would do this as a court is you would find the provision that's unconstitutional or illegal or otherwise whatever. You'd say these provisions are illegal. Here's the provisions. The other provisions are legal. And then you would say, can the statute be saved?
Yeah.
Right.
My question would be they're citing to Hellerstedt. I don't know. I haven't looked at Hellerstedt, so I don't know what exactly that says that they are citing to for support for that. I mean, other than the quoted portions.
Yeah. So I don't. This quoted portion's not doing anything for me. I mean,
because plenty of laws have been struck down as partially unconstitutional. But Section 230 is an example.
Section 230 is maybe the best example because the rest of the CDA, the entire rest of the CDA was struck down, but Section 230 remained. That was a lot. I mean, they struck down a lot of stuff, and they still maintained 230.
Yeah. So I don't know that maybe there's a good reason coming out of Hellerstedt for why that should be the case in this situation. But I mean, my instinct is to say that probably is not correct.
I'm not buying it at all. It's like because this is invalid, this necessarily must also be invalid. How does that flow logically?
Especially because the actual text of the statute itself says that if one part is deemed unconstitutional,
they're going to get there in a second too.
Yeah,
and the court doesn't apparently care about that. The same must be said for the entirety. The same must be true for the entirety of SB 8. For the provisions are unconstitutional in their face, including a severability provision in the law does not change that conclusion. Yes, it does. What are you talking about? That's kind of the point of a severability clause. To say that these provisions are illegal, the whole point of a severability clause is to say other provisions are legal. That's the entire purpose of it. What are you talking about? It doesn't change the analysis. What are you smoking? I don't get it. The state argues that the court should find any provision should the court find any provision of SB 8 to be unconstitutional, it should sever such provisions from the law and remain provisions intact. Yeah. In support of this request, the state cites the severability portion of the law, which confirms that Texas legislature intends all provisions to be severable, that it would have enacted any and all provisions regardless of whether any provisions are subsequently determined to be unconstitutional, and each provision is severable. I mean, the Texas legislature couldn't have made it any more clear.
Right.
They couldn't have made it any more. And then they have this wonderful thing that's like, we'll sever every word from every sentence, from every paragraph, from every section. Go ahead and quote our stuff now. So, yeah. What does it have to teach us?
Yeah. Well, so then if you continue with the highlighted portions, you've got more out of Hellerstedt. So, however, as the Supreme Court wrote in Hellerstedt, our cases have never required us to proceed application by conceivable application when confronted with a facially unconstitutional statutory provision. Such an approach would be quintessentially legislative work outside the bounds of the court's ordinary review. I mean, I guess like different from Section 230, you could say, the rest of the CDA was like, wasn't it about like regulating CP or something like that? The rest of the
and not necessarily just CP, but like objectionable content more broadly.
Okay.
It was kind of a little bit Christian conservative.
Okay. So
lewd things are bad.
Right. And then Section 230 obviously is like, all about moderating and that kind of stuff. So, I mean, I can understand how those are kind of two different, you can separate those two as like, two distinct, like not regulatory areas, but like, you know what I mean? Like these are two things that can kind of exist on their own. But I think that maybe what she's getting at, or she or he, the judge here, is getting at is that, once you determine that the core of this law is the heartbeat portion of it, right? Like whether or not they can regulate this, whether or not they can provide this right to sue for any individual for, an abortion after 6 weeks or whatever, where there's a heartbeat. But it's like, if as soon as you determine that that's unconstitutional, you don't necessarily, like, there's really nothing left in the act, right? Like, substantively.
Not really, but for better or worse, presumably it would have to stand by Texas's own rationale.
Right.
So it may be a very hollow law that basically does nothing, but
Yeah.
that's the way Texas wants it explicitly.
Yeah.
So,
Yeah. Because
okay.
I think because they probably want there to be their statute to say, if Roe v. Wade ever gets overturned, there's that provision that they said, if Roe v. Wade ever gets overturned, then this recognizes that the state of Texas has never allowed the right to an abortion or something like that, like, and it would go back to those laws if Roe v. Wade were overturned as to Texas. So there's like stuff like that.
And then they say this approach would be quintessentially legislative work outside the bounds of review. Well, maybe, but yeah, it's a weird thing because, like, okay, by Texas saying you can fix this, it makes it legislative work. So they're basically saying the severability provision is too broad, which seems odd, but all right, sure.
Yeah, but
Here,
I guess my point is that, like, functionally speaking, this legislation just would not have any teeth. It wouldn't do anything, right? Other than those, like, other random small portions that would go into effect, like, if Roe v. Wade is overturned, et cetera, et cetera.
well, so be it, I guess. But that's what Texas wants, I guess.
Right. Right.
Here, as there, the court rejects Texas's invitation to pave the way for the legislature to immunize their statutes from facial review. I don't think they were. The United States also separately asserts as-applied challenges based on SB 8's interference with federal officers and programs that provide or facilitate abortion. Under the doctrine of preemption, state laws are in conflict when they're with federal law. State laws are also preempted when they stand an obstacle to the accomplishment and execution of the full purposes of objection to Congress. So, yeah, as I kind of said before, this stands for the proposition you can't interfere with the federal government. You don't necessarily have to help, but you can't interfere. Okay.
Right. And I think that the federal preemption doctrine also includes laws that are created by the Supreme Court.
I think that's right. We had a bit of a discussion off camera about that, and I think you're right on that as well.
Yeah.
I just wanted to acknowledge the point that, you made that point and I was wrong and you convinced me because I think it's important.
Well, thank you. I appreciate that.
Credit where credit's due, right?
I mean, and I wasn't entirely certain of it myself, so I'm glad that we just decided to look it up and find out what it actually was. So, because I had a gut instinct, but I didn't know for sure. So,
absolutely. As a response to the arguments that SB 8 is preempted by federal law and violates the principles of intergovernmental immunity, the state's primary argument is that Texas courts are unlikely to interpret the act to apply to the federal government. Yeah, this is a bit of a problem for the law standing. However, this argument is ineffective for two reasons. First, SB 8 does not explicitly declaim its applicability to the federal government. Yeah, that was a slight fail on the people who drafted this. That was a slight fail on the people who drafted this. It would have been better if they had a clause that said, notwithstanding any other provision, no federal employee or federal contractor can be held liable for the performance of their official acts, and something like that. It would have been better. But yeah, they didn't say that. So literally on its face, it does apply to the federal government.
Yeah.
And their argument is, the courts are unlikely to consider it that way. That argument's lame. On its face, it applies to the federal government. You missed one.
Yeah.
You missed one.
Strike one.
This argument is ineffective for two reasons. It does not explicitly disclaim, and second, without the disclaimer, doctrines of preemption and intergovernmental immunity are violated regardless of anyone sues it. I'm sold. This was a fail. Now, the way to fix this, incidentally, because Texas is already giving you the permission, the way to fix this problem is simply saying, okay, as a matter of law, this cannot provide, that the legislature might on it, but they carved it, gave me a big card out. So just as a matter of law, this cannot apply to any federal employee or federal contractor that or other act that is, other act that is consistent with statutory, just something along those lines to create to avoid the problem.
Right.
So yeah. So they were pretty genius, but they did miss one.
Yeah.
I guess no one can be perfect. Despite the state's attempt to obscure the question, the irreparable harm inquiry is really quite clear. People seeking abortions face irreparable harm when they're unable to access abortions. Okay, but the problem with that, again, is that would be an argument for those people. And, yeah. These individuals are entitled to access abortions under the U.S. Constitution. SB 8 prevents access to abortion. A preliminary injunction will allow, at least for some subset, abortions to proceed that otherwise not would have. Okay.
Yeah, I mean, I think that would be a good argument if the God, what's it called? The parentis one.
Yeah.
if that doctrine is found to be upheld in this situation.
Yeah. So we've gotten to the end of the discussion. That wasn't too bad for an hour 41.
Yeah. It's funny how Indy always seems to know when we're almost finishing up. And that's when she starts like pawing at me like, "Hey, you done yet?"
Psychic dog.
I guess so. Puppy bear.
So, Alita, why don't you start? Just give me your overall thoughts of the court's decision.
Yeah, I think there's I think that they probably came from a place of bias, to be like political bias. I think I get that sense, but I think that they maybe tried to have a good reasoned argument. And there are some arguments that I think are very compelling. Others that I think are a little bit weaker. But the issue about federal agencies, federal contractors, et cetera, I think that's pretty compelling, actually.
Yeah.
So,
question from the chat. 0ISNI 0 is 9. 0 is 9. Okay, 0 is 9. Okay. How does the Hyde Amendment interact with the cases where the federal government does provide abortions? So that's a good question, and part of my reason where I was like, I doubt it that they explicitly do. But there was there was a provision in there that seemed to suggest that they do fund the abortions in the case. Let me see if I can find the language in the case that discussed this for the Bureau of Prisons. Because there was language that implied they funded it. Okay, yeah. Apparently, this is what it says. There's just a statement in here. It says, the Bureau of Prisons further bears all costs of providing an abortion in the case of rape or incest. Okay. So apparently,
which that would, I mean, that right there is something that the state of Texas is regulating, is saying that they're not allowed to perform abortions that intersect.
Yeah. So I don't know how that is or is not in conflict with the Hyde Amendment. It's a reasonable question because the Hyde Amendment basically prohibits the federal government from funding abortions, but it seems like they do here. Mm-hmm. So I'm not sure how that's a thing, but okay. Otherwise, yeah. Did you have any other thoughts on the legislation on the court opinion of the whole?
I think that it's not the strongest opinion, when it comes to the actual reasoning of the opinion, but I think I would say it's a mixed bag personally for me.
Yeah, I think okay, first of all, as to the judge's bias, because this was a point Alita pointed out earlier before recording, the court does refer to it as pregnant people,
which was as soon as I saw that, I started to notice like, okay.
And then we had a fun discussion about how Alita, because men and women are equal, how does it feel to be a man? And then we had a whole fun discussion along those lines.
Yeah. So I do think that there is a little bit of a political bias here, but just based on that, and then the thing about equity that came up in the opinion. So yeah.
Well, they get a bit of a buy because it's not like equitable causes of action or something. They're inventing whole cloth, although they're inventing this equitable cause of action whole cloth. So there's that. But yeah, so I'll give my overall thoughts. I think the provisions dealing with the federal government are by far and away the strongest.
Yeah.
I've stated that many times. I thought Texas had some chances dealing with the issue because it seemed that in the way it was written that they only had to provide for services and it didn't seem like it was interfering. And then Alita points out that to the extent that they are doing that, it could be read as a violation of SB 8. So fair. And I think that's better overall conclusion. So I don't know what the Court of Appeals will say on this issue. I don't know if they'll agree or disagree or what they're going to say about that, or maybe they sever it out or whatever, or maybe they blatantly disagree. So when we ever get that far, and do you want to collab on that one? But we don't have a lot of time on it.
Yeah, I'll collab on that.
We'll collab on the Court of Appeals decision because we have to, and then you can join me for Scottish React where we listen to the oral arguments. Yeah.
Oh, oral arguments, man. Those are. Remember we did that with the cheerleader case? That was great.
I do remember with her confusion and
that was the first time that we had a real time reaction on live where we basically just. I don't know. I think
my favorite part of that stream was, to quote you, there were a lot of words. I said that's a lot, and then you said there were a lot of words.
There were a lot of words. I couldn't necessarily understand all of them because it was all in one paragraph run-on sentence, and I don't know if any human being could really understand them. But
yeah, it was a thing to behold. So yeah, as to the parent-parenti standing, there's some dicta. There's a decision from the Ninth Circuit Court of Appeals that seems to imply it. There's a decision from the Eastern District of Washington, district level court that seems to imply it. There is a Supreme Court decision that in dicta seems to imply it, but that's not a great swath of authority. I just quoted the three things that appear to support that proposition. So it's not like it's nothing, but it's not like a extremely well-established provision that, can bear all scrutiny. And to call it, blatantly contradicted or whatever the court said is insane. So, and also for my money, I don't think this current Supreme Court's likely to go that way. So I don't think they're likely to go with that parent-parenti standing. Part of the problem also, as Texas pointed out and was not really addressed by the court as I saw it, was that in other examples, there's legislation that gives the federal government the ability to sue, or gives the federal government an explicit cause of action, and that wasn't true here. So they're trying to manufacture something that Congress didn't give them. So I thought that was also pretty good. But yeah, I thought there's some weaknesses in this decision. So when we get to the Court of Appeals decision, have to reason through that. I guess we will.
Sounds good.
Yeah. And Waximus says, what happened with the law? I don't know yet. It's at the U.S. Supreme Court. So we'll find out relatively soon because oral argument is in 7 days.
Yeah, those
8
poor
days.
people.
9 days.
Oh, jeez.
Yeah.
Those poor associates.
Yeah, those poor associates. So we don't know yet, but it's going to be interesting. And the Supreme Court's usually not that fast to act. So, but the timing suggests that they are likely to come up with a decision pretty fast. So we might have it in time for Thanksgiving, which, just the right time to come out with it. That'll be great. Just release it on the Wednesday before Thanksgiving. Make everyone's Thanksgiving even more memorable. That'd be fantastic.
Get into some robust family discussions. Right?
Yeah. John O'Brien says, do you think it will be resolved on procedural grounds or will they adjust the substance? The substance is not an issue before the U.S. Supreme Court. The issue is all procedural. Can the U.S. government sue? Can the U.S. government sue the courts, the court officers, someone else, I think maybe executive officials and or the people at large? So it's all procedural. Can the U.S. government bring this suit? It's not going to get to the substance of the case. So no.
Yeah.
And I already can write the fiery dissent from Sotomayor in my head, which is depressing. Not hard to predict how that's going to go.
Yeah. And
I mean,
at least she's consistent, right?
And it'll be interesting where Robert stands on the procedural issues. I mean, if you had to guess, you would guess that he would stand with the liberals on this one or the progressives on this one. which is depressing.
I think he probably will because of his descent to the non-stay, right? Oh my gosh, seriously. Shh.
But even he said it presented conflicts issues, so maybe there's a chance.
No, that's true.
When they get to the case from Alabama, isn't it? From Alabama, or is it Mississippi? Which one is it? It's one of those states. It's a state. When they get from the case from a state where they're basically reevaluating Roe, though, I think Roberts is very extremely likely to be on the left on stare decisis grounds. Which, fine.
I can't remember which state that's going to be.
It's Alabama, it's Mississippi, it's one of them. It's like,
Yeah.
Yeah,
Pretty sure it's a southern state.
It's 6-3, so we can influence the writing. Well, the only way, strictly speaking, he can influence the writing is by assigning the case to himself, which he could do. Because, the senior most justice determines who gets the case assignment in terms of writing it. So the only way for him to do it is for him to be in the majority and for him to write the decision. And I'm not sure he necessarily wants to go down that road, but it's a valid point. In any event, I've had a lot of fun.
Yeah, me too.
Alita, why don't you tell our friends where they can find you and other stuff about your channel?
Of course. Yeah, you can find me on YouTube. Just look up Legal Bites. You can find me on Twitter, on Locals, on Instagram, on Facebook. I'm pretty much just about everywhere. If you want to come check out all the stuff on my channel, come on by and subscribe. I do live streams once a week, and I also try to do a pre-recorded kind of published sort of stuff also, answering particular questions. Usually the weekly live stream, I like to talk about 2 or 3 different topics that have come up within the last week. And I love having them by discussion with other YouTube lawyers, such as Kurt at Uncivil Law. So because I find those to be so much more fun and engaging than just me talking to the camera, and and occasionally the chat too. Of course, it's helpful when you have a more robust chat. But it's yeah. So
it's nice. It's nice to be able to check my thinking and my reasoning with a fellow professional who can talk to me in a way that I understand, because they understand the background issues that are all at play. It's like we all have this massive latent understanding of law from like the bar and stuff. So it's like we understand so much latent stuff that we can, and it's never like expressly expressed, but the way that things are expressed, like, communicates the background knowledge, or that it's there. It's like, so it's like we don't have to establish like the entire foundations. So it's very nice. Alita apparently is frozen. Alita apparently has ended the stream. Well, that's very sad for all of us because Alita's gone now. Well. So that's the end of Alita, but at least she gave us all the things. Remember to check out. Oh no, wait, she's back. She's back. Hold on.
Hey, sorry, I don't know what happened. My internet went out for a second.
Oh man.
But yes, I agree. I agree with what you were saying, that it's great to have another person that you can check your thoughts with, and that kind of understands the stuff. No, I totally agree. That's why I love having the like the panel format for live streams.
Cool.
So,
well, I've been Uncivil Law, and I do now have a Locals. It's uncivillaw.locals.com, and we will be posting some more stuff on there, probably the raw videos, and before we cut them up for new stuff. So there'll be more full stuff, and that will be members only stuff, but we'll post some more things on there as I figure out more what to do with it. So you can check me out on Locals and subscribe to me there if you're interested. It will also be a nice backup in case I get yeeted from YouTube. So there's that. If you have not already subscribed to the channel, why not? There's a big red subscribe button. Just click the big red subscribe button, and YouTube will get more wonderful legal educational content as we try to decipher and explain the law one bite at a time.
Heck yeah. And be sure to like the video.
Yeah, like
if you haven't already.
Like the video, and if you're not already an uncivilian, you can become an uncivilian. How, you might ask, how do I get this illustrious status? It's easy. For 99 cents a month, all you have to do is click the join button or the link that Streamlabs has been telling you from time to time. 99 cents to be a member. It is literally the cheapest membership on YouTube because there's no price point lower. It is the lowest membership. For 99 cents a month, you get to support the channel financially, help the channel grow, you get a cool little icon by your name, and most importantly, I will like you more. So do all those things. I've been Uncivil Law. My guest has been Legal Bites. Until later, my friends, I hope all is well, and cheers, and goodbye.